This is the In Focus podcast from The Hindu.
Hello and welcome to another edition of the In Focus podcast. I'm your host, G. Sampath. A 5-judge constitution bench of the Supreme Court has upheld the abrogation of Article 370 and the subsequent reorganization of the state of Jammu and Kashmir into 2 union territories. While this judgment has been hailed as a historic one, it has also raised concerns about subversion of the federal system, which is understood to be a part of the basic structure of the Constitution. So what exactly was the judicial reasoning and the thought process behind the Supreme Court judgment, and what are its larger implications, especially for Indian states and the federal structure? We discussed this judgment in some detail in this episode of In Focus, and we have with us Krishnadas Rajagopal, the Hindu's legal correspondent. Krishna, thank you so much for joining us.
Thank you so much, Sampath, for having me on this program.
Great to have you. Krishna, to start with, I was just wondering if you can just give us a brief overview of the reasoning in the Constitution Bench's judgment that has upheld the abrogation of Article 370 of the Constitution.
Yeah, so this was a 5-judge bench headed by Chief Justice of India, D.Y. Chandrachud. And the lead opinion was given by the Chief Justice himself, and he shared the opinion with Justices B.R. Gawai and Justice Suryakant. So 3 of them had the same opinion. And then there were 2 separate but concurring judgments or opinions by Justice Sanjay Kishan Kaul and Justice Sanjeev Khanna. They were separate, but they agreed with whatever the Chief Justice said. Now, it's a 476-page judgment. I mean, all the 3 opinions got together is around 476 pages. Now, as you said, Sampath, they upheld the abrogation of Article 370. That's the basic thing. The reasonings include that, one, Jammu and Kashmir did not retain any internal sovereignty after the execution of the Instrument of Accession in 1947. Second, they found Article 370 was a temporary provision, just a mechanism to integrate Jammu and Kashmir, the state of Jammu and Kashmir, more and more into the union. It was a gradual process over the years. And this was the culmination of that process of integration. And thirdly, the dissolution of the Constituent Assembly, which we'll be talking about later on, the Constituent Assembly of the state, did not affect the president's power to abrogate under Clause 3 of Article 370. Fourthly, the court did not go into the legality of the declaration of the president's rule in December 2018. The president's rule had followed the governor's rule, and but at the same time they basically came out with certain ground rules in connection with first they said that if the declaration itself will come under judicial scrutiny. For this, they banked on the 9-judge bench decision in S.R. Bomme. And they said that, that the president's actions during the subsistence of the president's rule and also the declaration itself would come under greater scrutiny. This is what the S.R. Bomme case also said, the judgment also said. They just reiterated it. And one of the ground rules that they put out in the judgment was that there should be a reasonable nexus between the object of the proclamation of Article 356 and the actions of the president / the parliament during the subsistence of the during the period of the president's rule. Having said that, they did not apply any of these ground rules, especially this one, that whether there was any reasonable nexus between the object of proclaiming Article 356, the President's Rule, which is Article 356 basically says the President's Rule kicks in if there is a breakdown of the constitutional machinery in the state. So the object of Art 356 and later on the final action that happened in the 350, that is the abrogation of 370 and the bifurcation of the state itself into two union territories. So, was there a reasonable nexus between the president's rule, the object of the president's rule, and the abrogation of the 370 and the bifurcation of the state into two union territories? That the code doesn't say. There's a big blank there. And basically, to add to it, the code says that we don't want to get into the reason why the president abrogated 370. Maybe there must have been some special circumstances which call for a special solution. And we don't want to sit in appeal over the president's action. So there is a slight contradiction there between fixing certain ground rules and not applying it in the case at hand. And finally, another quizzical thing is that they did not go into the legality of the Jammu and Kashmir State Reorganisation Act, which actually divided the reorganized the state or bifurcated the state or carved the state into two union territories. They did not go into the legality of it. Instead of that, they just took the assurance of the Solicitor General that we will be restoring the union territory of Jammu and Kashmir back to statehood, full statehood, as soon as possible. And having believed that and having recorded that, and they went on to direct the Election Commission of India to say that you have to conduct elections by September 30, 2024. Now, you have to mark the point here is that they have not given a deadline for the restoration of the statehood, but they have given a deadline for the election. And they have believed the solicitor's word on that. Now, as I believe Justice Rohinton Nariman also commented on it a couple of days back. So he basically said that, how could you basically do that when, you can't, you can't restore, you can't promise, you can't take the word of a Solicitor General, a government. The government may change and the status of Jammu and Kashmir may not in the future. So a constitutional court being given a specific question on the validity of State Reorganisation Act chooses not to apply its mind on the legality of the act, but takes the word of the Solicitor General of a government center which may or may not change later on. But the status of Jammu and Kashmir there is a possibility that the status of Jammu and Kashmir may continue as a union territory. So there is no, the basic point is there is no deadline given for the restoration of the statehood. It's just a general comment that, do it as soon as possible. And then I think these are the basic takeaways from the judgment. Sampath?
Right. Thank you so much, Krishna. And that's really a very comprehensive and crisp overview of the verdict and also the contradictions, some of them which are there. Really appreciate your laying it out so well. And I think I'm really keen to get to know more about these in particular 2 points which you mentioned. One, of course, is the nexus between the reason for applying President's Rule, which is to do with breakdown on constitutional machinery, and what you actually do once the President's Rule is in place. Is there a nexus between the two? Ideally, according to the ground rules, as you said, there should be, but is there in this case? The Supreme Court judgment is silent on that. That is, of course, a very important point. And secondly, when the reorganization or the bifurcation of the state into two is also in question, the entire legality of it is sort of bypassed. And the Solicitor General's word is just taken at face value, which is again very interesting. We'll come to that in a bit, Krishna. In the meanwhile, I wanted to ask you about something else you referred to, which is the question of sovereignty or internal sovereignty. The petitioners had argued that J&K retained an element of sovereignty when it joined the Indian Union in 1947. And this arrangement, according to them, was distinct from the relationship that other princely states had when they merged with India. So, how exactly did the Supreme Court bench conclude that Jammu and Kashmir had no quote unquote internal sovereignty?
I'll start with what the petitioners, argued. They said that this Jammu and Kashmir came into the union fold on the basis of an instrument of accession. It was not a merger. They had retained some residual sovereignty. And the government countered that, no, they came into the fold of the Union of India, and later on they participated in the framing of the Constitution of India. And the Constitution of India, once it came into existence, once it was promulgated, is the supreme document. Now, the court tackles this question of internal sovereignty in multiple ways. It looks at it theoretically and it looks at it very practically, factually, what happens. So I think I'll start with the factual part. This is basically the lead opinion, which is detailed. It says that on November 25th, 1949, there was a proclamation for the state of Jammu and Kashmir by Yuvraj Karan Singh. He was a successor of Maharaja Hari Singh, who signed the instrument of accession. And basically, the proclamation said that the relationship between India and Jammu and Kashmir will be governed by the Constitution of India upon its adoption by the Constituent Assembly. That is, I think I have the exact words of the proclamation. The proclamation says this proclamation reflects the full and final surrender of the sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. So Chief Justice Chandrachud takes this up, and he says that this is the same as a merger. He says maybe what you're saying is right. Instrument of accession is not a merger, but then there is a subsequent proclamation by the Yuvraj on November 25th, 1949, which basically says that once the Constitution of India comes up or is promulgated, we are governed by that. So what more can you want? This is exactly a merger. And then the court says that now look at, goes to the Constitution of India itself and says that look at Article 1. Article 1 says that India is a union of states and Jammu and Kashmir is listed as one of the states. Then look at 370 itself, how 370 is being used as a mechanism is used to apply more and more of the articles of the Indian Constitution into the governance of Jammu and Kashmir. And then he goes to Jammu and Kashmir Constitution itself, Section 3, which says that Jammu and Kashmir is an integral part of India. And then he goes to the preamble of the Jammu and Kashmir Constitution, and he says, I'll quote, Jammu, in pursuance, the preamble says, in pursuance of the accession of Jammu and Kashmir to India, to further define the relationship of Jammu and Kashmir with India as its integral part. So basically, the court is trying to say that we've shown you multiple documents. The proclamation, the 1949 proclamation, the Constitution of India itself, and then the Jammu and Kashmir Constitution itself, which the Constituent Assembly of Jammu and Kashmir, the people, had ratified. So that they all agree that Jammu and Kashmir is an integral part of India. It's part of the federal structure of India. And then there is the theory part, which says that what is sovereignty? Is the state a sovereign or the citizen a sovereign? Now look at Jammu and Kashmir. The Maharaja sent 4 of the representatives of the state to sit in the Constituent Assembly of India to frame the Indian Constitution. And mark you, Sheikh Abdullah was one of the 4. And they all helped in the preparation of the Constitution of India. Now, the citizens wanted to be under the sovereignty of the Union of India, the Constitution of India. So he said, there is nothing. He said, the Chief Justice said that internal sovereignty and external sovereignty, they're all the two sides of the same coin. They're indivisible. And the actual sovereign power rests with the people of Jammu and Kashmir. And through their actions, through all these documents, through the actions of sitting in the Constituent Assembly of India to frame the Indian Constitution, they have accepted that they are part of the federal chain, which links the Union of India and makes the whole of the Union of India. Now, again, another theory part, interestingly, he has said that you have muddled up autonomy and sovereignty. Is it what you're seeing is asymmetric federalism, which is a differential autonomy. Asymmetric federalism is basically that some states are get more rights, and some have special interests. Like you have that in Mizoram. You can see that in the Constitution. The Constitution backs it. The Indian Constitution backs it. Mizoram under 371G and Nagaland under 371A. They are all examples of asymmetric federalism. So he said Jammu and Kashmir had never had sovereignty. It just was part of the asymmetric federalism. It was only asymmetric federalism was being followed, and you have basically what you thought that it was sovereignty, but it's actually autonomy. And interestingly, there is this book that I read, Robert Agronoff. So he says that what is asymmetry? Asymmetry depends upon a polity sufficiently flexible, accommodative, and innovative to incorporate complex differences and identities which have political salience. So a couple of things. So theoretically, they have tackled it by saying that Jammu and Kashmir never had sovereignty after the instrument of accession. What you saw was not sovereignty, but just differential autonomy, asymmetric federalism, and then factually they have gone into how all these documents, the 1949 Proclamation, the Constitution of India, Jammu and Kashmir Constitution, all these documents basically say that there is no sovereignty left. We are an integral part of India. We are just a state, and we have not retained any residual sovereignty with us.
Right. So, Krishna, just one quick question here. So, on you sort of detailed the answer on two parameters. Let us say one is a theoretical and one is a factual. And going a little bit on the factual side, this accession, this instrument of accession, which is Article 370, that is a fact. Okay. Now, if some would argue, and I have seen this argument being made in different texts, that you have Jammu and Kashmir as an integral part of India through Article 370. I mean, Article 370 is the conduit through which the Constitution of India applies to Kashmir. Now, if that is taken away, then what do you have left without that conduit through which? And if you in order for that to be taken away without breaking that integral link, you need the people, whether you call them sovereigns or whatever, the people to consent to take this Article 370 away so that you are more fully merged rather than acceded or whatever. So did this come up in the judgment or in the discussions and so on? Like, how is this?
I think you're talking about Article 3, where, there are two provisos in Article 3. The first proviso, which says that if you want to change the area or the name of a state, you have to refer the proposal. The Parliament has to refer the proposal to the state legislature and to they have to get the consent of the state legislature. This was basically a very pertinent question that the petitioners put to the court. And this was one of the questions that was referred to the Constitution Bench. But sadly, they did not answer it. They left it open.
Yeah, so I was going to ask you, what about then this Article 73? I think that's what you were referring to, which then said that the recommendation of the Constituent Assembly of the state, a Constituent Assembly which did not exist at the time when the abrogation of Article 370 took place. Now, this abrogation then is essentially infructuous, according to the petitioners, because there was no constitutional means to abrogate Article 370 in the absence of the Constituent Assembly. So this contradiction, how did the court address this question? Like when there is no Constituent Assembly which was needed to abrogate 370, how did this abrogation become legally valid?
Now here, basically the finding, let's start with the finding, the conclusion. Says that the president shall have the power to unilaterally abrogate 370. I mean, president, which is basically saying that the president doesn't need the recommendation of the Constituent Assembly to get rid of the article itself, to get rid of the special status of Jammu and Kashmir. That's what it's basically saying. Now, two arguments placed by the court. One is that as you know, the Constituent Assembly ceased to exist in 1957. And the court basically says that it was never a permanent body. You can't compare a Constituent Assembly with a Legislative Assembly. The Constituent Assembly is there to ratify a constitution. It's there for a limited purpose. And in the case of Constituent Assembly of Jammu and Kashmir, it was for two purposes. One is to get a final call on whether Jammu and Kashmir wants to completely go into the jurisdiction of the Union of India, and two, to ratify the Jammu and Kashmir Constitution. Now, what has happened here is that they ratified the Jammu and Kashmir Constitution, but they didn't take a positive recommendation on whether they want to continue with, they didn't take a positive recommendation on whether they want to continue with the Union of India, in the Union of India, or find an alternative. Now, having said that, the court says that the recommendation of the Constituent Assembly of such a temporary body was never binding on the president. So basically, it's a very interesting. They take a bit from history. They basically interpret Should I read the clause 3 of 370? I think that'll make it easier.
Sure. Yeah.
Says, notwithstanding anything in the foregoing provisions of this article, the president may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. And this is where the point comes. The proviso says that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the president issues such a notification. So here the proviso says it is necessary to get a recommendation from the Constituent Assembly. But what the court says is that it has never been binding. One, the Constituent Assembly was a transitional body. It was just there and it was never permanent. The second, they say that what you have read in clause 3 is just see, at that point of time, the princes of the rulers of these princely states, they had to ratify the Indian Constitution. Now, they had to ratify the Indian Constitution after taking the recommendation of their state constituent assemblies. Now, there were instances where the state constituent assemblies would want certain modifications, certain changes to be made in the application of the Indian Constitution to their respective states. So basically what they are saying is that this clause 3 of 370 it just encapsulated this procedure. It was nothing more. And once the Constitution of Jammu and Kashmir was made, the Constituent Assembly ceased to exist. But the president's power did not cease to exist. Because if you go to clause 1 of 370, this is what the court says, goes to clause 1 of 370, the president is the one has the power to notify changes in the governance of the Jammu and Kashmir Constitution. The president has the power to apply more and more of the articles of the Indian Constitution into the governance of Jammu and Kashmir. Parliamentary laws made by the parliamentary laws. The president had the power to notify the parliamentary laws into Jammu and Kashmir with the concurrence or consultation of the state government. So the president was always active. He's always been there, and he's always been doing this gradual process of integration. He was key to it. And another thing, what they are saying is that if you say that Article 3, Clause 3 of Article 370 cease to exist, if you say that, then where will the integration process go? That will be the end of the integration process, right? So you're saying that so you can't let Clause 3 of 370 die just because the Constituent Assembly does not exist. The president is there. The president is doing more and is the key to the integration process. So his power to do that, to act as
the very article which you are abrogating, you draw the power to abrogate it for the president from the article you're abrogating.
Exactly. Yes. In the sense that, you basically, at one point, you're saying that 370 is key to the integration process. And all these decades, we have been using 370 to integrate Jammu and Kashmir more and more into the Union of India. So the question is, basically, then why do you abrogate 370? If 370 is key, if all these years you have depended on 370 to integrate, then why do you get rid of 370? You continue doing that. But what they have done is that they have abrogated 370. So there are these contradictions which are, there are these hiccups where at one point you're saying that, 370 is key to the integration. And at the same time, you're abrogating 370. You don't need 370 anymore.
Right. There's also the question of, if 370 was a temporary provision, what about, amending it in Parliament first under the provisions of Article 368, and then going ahead rather than have the president do this? That's another question which I think has come up in this context.
Where is 370 placed? 370 is placed, I believe, in Chapter 21, the temporary and transitional and special provisions of the Constitution. So the court gives a very subtle answer. If something is temporary, why do you need to amend it? It will die on its own. When the circumstances for which it was brought into the Constitution ends, it will die on its own.
Oh, but it didn't die on its own. No? The government had to abrogate it.
And the other point
somebody
is
had to kill it. It didn't die. Yeah, please go ahead. Yeah, you were saying about the temporary nature of Article 370.
Yeah. So why was 370 not abrogated in the 368 way, the amending power of the Constitution? That's basically the question here. So so the court basically says that look at where 370 is in the first place. In Chapter 21, which is a transitional temporary provision, and so every temporary provision need not be amended under Article 368, which is what the court says. Now, temporary provisions are brought into the Constitution for certain exigencies in special circumstances, and with and it will automatically cease to exist with time or changes in the peculiar conditions under which it was brought in. That is the court's logic here.
So would that then apply to all the other provisions in Chapter 21, which are temporary? Anything for all of them, we can do what we want without amending them, directly getting the president to do it? Or is there any criteria?
That's the logic they brought in. That's the logic they brought in here. I'm sure somebody would, maybe in the future, people would question this. Maybe this will come under further examination. And Sampath, we are dealing with the Constitution Bench. It's a 5-judge bench. It's not a division bench where you can appeal. This is a reference on a constitution question. And one of the specific questions asked to the Constitution Bench was this the way to do it? And the other thing that they have brought in was that they've said that, which is more plausible of an explanation. They basically said that 371 and clause 1 of 370 and clause 3 of 370 have specific procedures. Listed out specific procedures by which abrogation of 370 can take place. And 371 is basically bringing in, articles of the Constitution, Indian Constitution, into the governance of Jammu and Kashmir and all that. But keeping that aside, they're saying that clause 3 of 370 has listed out a particular way of abrogating 370. Now, they've already proved that the president's power to abrogate is not affected by the absence of the Constituent Assembly. Having said that, they said when there is a particular way in which the abrogation can be done, the president can follow that, and he can unilaterally notify the cessation of Article 370 that way. When there is something in the article itself on how it can be abrogated, why bank on 368? And also, there is this, Jammu and Kashmir Constitution Order. It's Constitution Order 48, which is basically the 1954 order, Jammu and Kashmir Constitution Order 1954, which brought in Article 35A. 35A brought in the permanent residence, brought in more rights for the state, for the people of Jammu and Kashmir, voting rights. So that was done with when the Constituent Assembly was in session. So basically, they are saying that at that point of time, the procedure clause 370 procedure was used to amend the Constitution of India, like bringing in Article 35A. So why not now? So they're basically saying that, listen, there is a procedure in 370, how to abrogate it. Follow that. We have followed that. And we don't need the help of a Constituent Assembly, because the Constituent Assembly ceases to exist and it has never been binding on the president from the beginning. So the president has done it.
Right. I got that, Krishna. Now, that is so far as the procedural part of it is concerned. Now, Article 368 is not just a procedure. I mean, there is also something underlying that. If you get out of this room, this box of law, beneath that is the will of the people. The people whose lives are going to be changed, affected in many ways. Which brings us to the question of the substantive nature of what this article is, which is democracy. Right? Is this what the people who are living in Jammu and Kashmir, is this what they wanted? Is this what their will reflected in? Now I was just curious, what does the judgment really have to say with regard to this question of democracy, of where the people or the people's representatives need to have their say on how what happens to their state, whether it's to do with boundaries being redrawn or the nature of the relationship with the rest of India and so on. So the people of Jammu and Kashmir and their say, which finds representation in law through whatever articles you have cited. I mean, many of it I'm not really qualified to comment on that. But on this fundamental question, I think many people would be interested to know the court's, the judgment's thinking on it.
So basically, I think your question centers on Article 3 of the Constitution, which basically there are two provisos to Article 3. And Article 3, I'll tell you, Article 3 is basically dealing with redrawing states and renaming states, state boundaries and areas and all that. And so there are two provisos to Article 3, which basically says that if the Parliament takes over as a state legislature, or the Parliament, if the Parliament makes a law for a state, it has to basically refer the law to the state legislature and get the consent of the state legislature. Now, in what has happened in Jammu and Kashmir was that there was a president's rule going on. So the parliament under Article 357, just one after 356, the parliament takes over as the state legislature. The role of the state assumes the role of the state legislature, and the president assumes the role of the government, the executive. So what the court says is that yes, we are talking about this Jammu and Kashmir State Reorganisation Act, which has actually bifurcated the state. So basically, what the court says is that yes, there was a president's rule on, and the president is the government, and the parliament is the state legislature here at that point of time. So the reorganization bill was referred to the parliament. The parliament found no malafide in that, and they passed it. And so the same. So that's the argument here. And then there is a huge void there. They have not gone into the question whether the parliament can extinguish the character of statehood by converting a state into one or more union territories in exercise of the power under Article 3. That thing is left open.
They haven't gone into this question.
They have not gone into the question.
Wasn't that the question of the entire case?
Exactly. So we have, I'm just digressing from this question. I'm just saying, so far in our discussion, we have brought out two blanks. One, the court did not go into the validity of the proclamation of 356. They did not do that. And two, they did not look into the validity of the State Reorganization Act. What the State Reorganization Act has done here is that it has actually bifurcated a full-fledged state into two union territories. So can this be done under Article 3? They have conveniently left it open. They said that at some point in the future, if this comes up, we'll have to discuss this.
Right. Now, this what you phrased as this extinguishing of statehood, through this entire process. I was just wondering, how does what does this actually mean in terms of federalism? For other states, can the center now? Is it fair to assume that the union government now has a clean sheet, sort of stamped with the authority of the highest court of the land? To bifurcate any state and turn it into a union territory after it imposes president's rule? Is that a legitimate concern to have?
Well, I think we'll have to whether there was a unilateral exercise of power here by the center. That's basically the crux of your question. I think if you can be a little patient, I have a little background here on that. Let's start with June 2018. Mehbooba Mufti resigns after the BJP pulls out. The governor's rule is declared the very next day with the concurrence of the president. There was no opportunity given to the Congress, the PDP, the National Congress Conference Alliance to demonstrate their strength in the House. The governor's rule at that point had in Jammu and Kashmir has only a life of 6 months. And while the governor's rule is on, the governor dissolves the Legislative Assembly in November 2018. He sends a report to the president recommending president's rule under Article 356. Article 356 is proclaimed. And according to the petitioner, the motion was passed without placing the governor's report in the parliament. Debates were not held approving the proclamation of 356 in the Lok Sabha and Rajya Sabha. And according to the Sakaria Commission, there should be an extreme political crisis in the state with no possibility to form a workable government. It's only in that situation that the president's rule is proclaimed or declared. But there was no discussion in the parliament, according to the petitioners. Now, December 19th, President rule was proclaimed. It was again extended in July for 6 months. A month later, after it was extended, there's a flurry of activity. Constitution Order 272 comes in. It's notified by the President in August, and it applies all of the Indian provisions of the Indian Constitution to Jammu and Kashmir. Immediately after, Constitution Order 273 kicks in. Article 3670 ceases to exist. No more special status to Jammu and Kashmir. October 31st, 2019, Jammu and Kashmir Reorganisation Act comes into existence. It basically downgrades a full-fledged state into 2 union territories. One, Ladakh, is without a legislative assembly. The same month in October, President's rule is revoked. So basically, where does this unilateral exercise of power kick in the first place? It is according to the petitioners, it is with the transfer of control of over Jammu and Kashmir from the governor to the president, in 356, without giving the people of Jammu and Kashmir an opportunity to restore governance in the state. The governor did not call the other parties to see if you want to test your strength in the house. No. And sadly, Article 356, the very purpose of Article 356 is to restore governance. But on the other hand, what has happened is that from governor's rule to president's rule, and president's rule, and finally it culminates in the non-existence of the state itself. And if the president's rule had continued, it would have continued for 6 months. And after that, whatever laws the president or the parliament had made could have been appealed or amended by the new legislative assembly of the state. But in this case, the legislative assembly was dissolved. And there was no coming back because, the state had been irrevocably, according to the petitioner, irreversibly changed. The character of the state had irreversibly changed from state to union territory. So basically, what we see here is that the court saying that, I don't want to go into the validity of why the president's rule was declared or the governor's rule was declared. I don't want to go into the validity of the proclamation because it's too late. You did not come on time. When the governor's rule was declared, you did not come then to challenge the governor's rule.
When did the petitioners approach the court for the first time? Not come on time? I thought this was pending for a long time.
They came after the whole thing was over. They came after the abrogation was done and the Reorganisation Act came into existence.
So when should they have come then?
So what the court here is saying is that you should have separately approached. When the governor's rule was declared, if you wanted to challenge the governor's rule, you should have challenged it separately. If you wanted to challenge the transfer of the governor's rule to the president's rule, you should have challenged it then. Now we are only about the abrogation and the State Reorganisation Act. We are not about the governor's rule, the validity of the governor's rule or the president's rule. But you see, the whole point is that we are about abrogation and we are about State Reorganisation Act now because the governor's rule and the president's rule set the stage for that to happen.
Right.
They are irrevocably linked. I mean, they are linked very close together. So I think, and the other thing is that they have S.R. Bommai judgment. They have quoted from S.R. Bommai judgment. They have said that, there should be more judicial scrutiny about the president's actions, about the declaration of president's rule, the validity of it. They've quoted everything. And they've also set down certain ground rules, which we talked about. But why have they not applied these ground rules to this particular case? That's also a question.
Right, right. Very interesting there, Krishna. Thank you for bringing in the historical context of this entire thing, which sort of sometimes gets ignored in the nitty-gritty of the law. I think history, what actually happened in 2019, I think that's very important to know. 2018 as well.
I just wanted to interrupt something. Just one more point to this, Sampath. The petitioners had brought in this argument that, now there's been an irreversible change in the status or the character of Jammu and Kashmir. So the court says that the argument of irreversibility does not apply here because, again, they quote Article 357, where they say that the president is the state government and the parliament is the state legislature. They both assume the role of these state entities during the president's rule. And when during Article 356, when the rule is subsisting, they can do whatever they want. They are competent to do things that they are otherwise not competent. And they're basically saying that there are no limitations on the exercise of power under Article 356. So that's also very interesting.
Right. So we're running out of time, Krishna. So one last question before we wrap up. Now, you are saying that under Article 356, on the one hand, you began by when the court's judgment seemed to indicate that there needs to be a nexus, between why it was imposed and what happened. But then at the same time, we are also seem to be finding that there is no limit to what can be done. If there is no limit, then why should there be a nexus? That question comes up. So my final question to you is, what does this mean for the federal setup? And we spoke about asymmetric federalism. I mean, even asymmetric federalism, one would assume in the common sense understanding would be, okay, asymmetry between the two poles, which is the center and the state. But here, the asymmetry is between different units of the second pole, which is the states themselves, where one set of states have a different kind of set of privileges and so on. But here, in the question of the fundamental question in terms of what is the guarantee that the federal setup will remain federal in spirit? If one pole can extinguish the other pole unilaterally, as we have seen, then how is it a federal setup anymore if a state can no longer have a guarantee of its own existence? On what basis does it stand as a state vis-a-vis the union?
In fact, in Jammu and Kashmir case, very interestingly, the Legislative Assembly of Jammu and Kashmir in 2000 had demanded the implementation of a state autonomy committee report, which said that we should be restored. The state should be restored to the pre-1953 status, because the status before the Constituent Assembly came into this thing, and they went without any abrogation and all that. So basically, they said that and I just pulled it out. They're basically saying that Article 370 has acquired a dangerously ambiguous aspect. Designed to protect the state's autonomy, it has been used systematically to destroy it. So I think the alarms were ringing way back in 2000 itself that autonomy is being slowly eroded, and we should do something about it. There should be a new article to supplant Article 370, and there should be a fresh compact between the union and the state. So there has been, it was noticed, and it was, people were in Jammu and Kashmir. I think at least the Legislative Assembly was aware of this. Now, what in this case, the larger perspective of this thing is that why did the court not examine the governor's role in the whole thing? The governor had he immediately called the moment the chief minister resigned. The very next day he assumes control. The governor gives a report based on which the president acted, and he dissolved the Legislative Assembly.
Wait, no. Speaking of this, why didn't the court examine the governor's role? I mean, again, this connects immediately with the larger context, the larger implications of what is going on. Every state which is ruled by an opposition party, the governor's role is under the scanner, not necessarily only in the media, but in the Supreme Court itself. Be it Kerala, be it Tamil Nadu, be it Bengal, the governor has been playing a kind of a role which has drawn attention, in a way that he did not earlier in history. And we have seen, as you said, as you rightly described, what the governor did in Jammu and Kashmir as well. So there seems to be some kind of a change in the way the governors of late have approached their function, with not very pleasant consequences for federalism.
So the whole point is, was the governor acting less as a constitutional statesman and more as a political ally of the union? These things have to be examined. This was not examined, and these were specific questions given to the Constitution Bench. Like, please examine 356, which would mean examining the governor's role also. And please examine the fact that the state was changed when it was under president's rule. The change is in the basic character of the state. It's been reduced into it has been bifurcated into union territories. Now, all these questions were not answered at all, or they not satisfactorily put into perspective. So that's I think that's what is alarming a lot of people. That's what this whole debate about federalism is coming into being, because basically the petitioner said that you bring in governor's rule, and then instead of giving an opportunity for the legislative assembly to come back and giving the political parties, a chance to form a government, a workable government, you immediately give it, before 6 months or you immediately give it to the president's rule. The president extends it, and the first month of the second extension, he brings out all the 370 ceases to exist. State reorganization is brought in, and the state is not there. And then at the end of the day, a constitutional court, instead of answering a constitutional reference or questions put to it, basically banks on the word of a solicitor general to say that we will restore statehood.
Right. No, on this one last question, Krishna. So this is a constitution bench, a 5-judge bench. So in case the petitioners want further relief, is there any scope for review or appeal or whatever on this judgment?
Well, I think they can. It's a constitutional reference. They can probably. I think recently there was a curative petition filed against the Constitution Bench decision regarding an arbitration agreement.
What exactly is a curative petition do? Like, what is its significance?
It's a rare remedy where there should be a very limited remedy where unless there is some bias on the face of it, apparent bias shown on the bench. If you can prove that prima facie, then the court will entertain the curative and look into it. Or if there is a problem which is insurmountable, which is affecting a lot of people, and then it's basically the court takes a call on whether it has to rehear it or redo it. But I don't think it's basically done. And here, what you see here in this judgment, it's an open, what we call an open form judgment, where you feel that December 11th the judgment is over, but then it's not over. At the same time, you have they've asked for elections. They've directed the election commission for elections. They've asked for whatever it's worth. They've asked the Solicitor General, or they placed their trust in the Solicitor General's word to restore statehood.
They've also asked for a Truth and Reconciliation Commission.
Yes, exactly. I was just about to come to that. Then Sanjay Kishan Kaul, whose last working date was yesterday. So he has written an epilogue where he says that, as you said, Truth and Reconciliation Commission to reach out to the people of Jammu and Kashmir. You have these. It's basically an open form judgment. It's not closed. It's not over. The problem is not solved. They know that. So I think when you think that it's over, it's not over. It's gone back to the people now. Let's see what happens. And also, there's a very dangerous comment, or there's a very dangerous argument from the government side. The government has basically put the border states, categorized the border states. They've basically said that the national security is involved in border states. So they brought in national security in Ladakh's case. So we need to keep Ladakh under our control. Now, what you have done here is that you've taken a whole state of Jammu and Kashmir, reorganized it, and you've taken one portion and made it into a union territory and reduced its power. You haven't given it a legislative assembly, whereas Jammu and Kashmir has a legislative assembly. So election is only for Jammu and Kashmir, a union territory of Jammu and Kashmir. Ladakh will not have an election, assembly election.
Thank you so much, Krishna. I mean, it was an absolute pleasure discussing this very complex judgment, which is invested with so much of history and so much at stake for so many. I think the story will continue, and we'll have to wait and see when the elections are held. Does Jammu and Kashmir get back its statehood, and what are the other possibilities from this judgment, which we will, I think, see unfold in the months to come. Thank you so much once again for your time.
Thank you so much, Sampath. It's a pleasure talking to you.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.